Have you seen all those videos of Mark Zuckerberg explaining how Facebook works to the Department of Justice all those years ago? Well, looks like Tim Cook's next, as the Department of Justice is gearing up to file an antitrust lawsuit against Apple. But there's more, and because of the recent developments, Apple is being attacked by Amazon and Microsoft, and it looks like Apple is in big trouble. According to Politico, the Department of Justice is in the early stages of drafting an antitrust lawsuit against Apple. The DOJ is claiming that Apple has abused its market power to oppress smaller tech companies. These companies include hardware makers and app developers in competition with Apple. The Department of Justice plans on pursuing the case by the end of the year, and if they do so, it will be the first case in the US against Apple by a federal agency. But for Apple, it's only part of the problems. Because European agencies have sued Apple regarding their App Store fees and the iPhone's treatment of tap-to-pay technology. Apple also found itself facing Epic Games in court when the latter sued Apple in relation to App Store fees. The trial between the two behemoths dragged on for months before ending in a frustrating stalemate. Coming back to the US, note that the DOJ has not yet decided to take any action against Apple. According to sources, the agency has been investigating Apple for a few years now. Nevertheless, the looming threat of a lawsuit from a federal agency means that Apple has to stay on its tiptoes and make sure it doesn't take a wrong step. Even though Apple has refused to respond to a request for comment, only time will tell how this saga unfolds. But until then, Apple's still caught up on another lawsuit that threatens the tech giant with a $14.8 million payout. If you've had an iCloud Plus subscription between 2015 and 2016, you could be one of the people eligible for it. The infamous Williams vs. Apple class action lawsuit is finally ending, as Apple has agreed to pay $14.8 million in damages. The plaintiffs in the Williams vs. Apple case accused the tech company of storing the data of iCloud subscribers in third-party servers without even letting them know. For a company that boasts data privacy, this was a serious breach of trust. The plaintiffs claimed that user data was distributed by Apple to third-party cloud services which include Amazon Web Services and Microsoft Azure, even though their terms and conditions mention no such clause. This was, according to the plaintiffs, a clear violation of Apple's own iCloud contract. Apple was also accused of not even possessing the required infrastructure to run its iCloud services. The plaintiffs claimed that the nature of its services was misrepresented by Apple and that the company was merely reselling cloud storage space on cloud facilities of other entities. Plaintiffs also claimed that the customers were fooled by Apple into paying the iCloud subscription fees. Had they known the reality of the service, they would not have agreed to pay the fees, or would have, at least, wanted to pay lower amounts. Plus, Apple, through the misrepresentation, was able to charge a premium on its iCloud services because the consumers placed a value on the thought that it was the Apple brand that was providing them with the services and not some third-party company. The case was finally settled recently, as Apple agreed to shell out $14.8 million in a settlement. However, this isn't the final amount that will go to the affectees. That actual amount will be the net of all legal fees. According to the settlement, the cap is set at $2.4 million and is supposed to cover all the expenses related to the settlement administration functions to be performed by the settlement administrator. Plus, one-third of the settlement, which is $4.93 million, was requested by the lawyers for the plaintiffs in attorney's fees. However, they were awarded a quarter of the settlement, which is $3.7 million. So, $8.7 million is what remains to be distributed. But distributed to who exactly? What makes a person eligible to get an amount? Well, all US residents who paid for an iCloud Plus subscription between September the 16th, 2015 and January the 31st, 2016 and had a mailing address associated with their account. Even if you do qualify for this payout, don't get your hopes high, as Apple has revealed that the number of people who qualify as eligible class members is 16.9 million. Yes, that's more than the number of dollars they're paying. The payout that will be made to each person depends on the amount of storage paid for, the length of your subscription, and, of course, the number of people participating in the claim. You can expect to receive your payment in a few days, and if you still have a monthly iCloud Plus subscription, it will appear as a credit on your Apple account. In case you don't worry, as they'll either send you a physical check through the mail or credit it directly to your bank account. Being the biggest company in the world, valued at $2.42 trillion, Apple faces lawsuits more often than not. According to The Verge, there is another proposed lawsuit against Apple in the works, this time against Apple Pay. The suit is being filed by Affinity Credit Union, an Iowa-based company that issues credit and debit cards that are compatible with Apple Pay. The company claims that Apple has an illegal monopoly over contactless payments, which allows it to force card users into paying fees. The company's lawyers are hoping to get other card issuers on board too by making it a class action lawsuit. Mentioned in the complaint is the claim that Apple makes over $1 billion annually purely from charging credit card companies up to 0.15% per transaction in Apple Pay fees. The company also made it clear that they don't have to pay any such fees when their customers use functionally identical Android wallets. The suit also claims that by making Apple Pay the only service able to carry out NFC payments on its iPhone, iPads, and Apple Watches, Apple violates antitrust law. Another claim was that, to prevent customers from looking for cheaper payment methods, Apple does not allow card issuers to pass on those fees to customers. A press release from the law firm handling the case stated that they aim, through the lawsuit, to change Apple's policies that force all contactless payments to go through Apple Pay. Another one of their objectives is to make the company reimburse card issuers for the fees that they illegally charged, according to the plaintiffs. However, the final settlement in a case like this mostly rests on the judge's decision. Even if the judge holds the plaintiff's claim that Apple has a monopoly over tap and pay iOS mobile wallets as true, they still might decide in favor of Apple by citing that such a monopoly does not exist because customers can always switch to Android, where other mobile wallets exist. Moreover, there is uncertainty regarding the plaintiff's wish to make it a class action suit. The final decision of getting class action status to a suit lies with the judge. However, luckily for the Affinity Credit Union, the law firm that is handling their case, Hagens Berman, is more than experienced when it comes to class action lawsuits against Apple. It was, indeed, Hagens Berman that got the developers a whopping $100 million settlement in a case that alleged that Apple's App Store's rules were unfair. Not only that, Apple had to pay $400 million back to customers in the ebook price-fixing case, and the firm behind this case was also Hagens Berman. With Apple finally making payments in a case involving AppleCare, in which the company agreed to pay a settlement worth $95 million, you might want to keep an eye on your emails. If, of course, you bought Apple's AppleCare Plus plan for iPhone and iPad between July the 20th, 2012 and September the 30th, 2021. And if you are interested in awesome videos that will blow your mind, you need to check out this channel. That's it for today.